Good afternoon, and welcome to Broadband Breakfast live online for Wednesday, August 14th, 2024. My name is Drew Clark. I'm CEO and publisher of Broadband Breakfast. Very excited to be with you again for another of our weekly episodes of Broadband Breakfast Live Online. We are a news and events community focused on better broadband, better lives. We bring people together around higher capacity internet and the use of that so that people can have access to the kinds of things that enable better education, better healthcare, better economic opportunities, working from home the way I'm doing now back at my home here. There's so many things that are enabled by better broadband. And at Broadband Breakfast, we bring this community together around them. We've been doing this weekly webcast for 4.5 years since the start of the pandemic, and we've been at it continuously. We do a lot of events on infrastructure and the way Congress and agencies like the Federal Communications Commission and the National Telecommunications and Information Administration implement laws of Congress so that we can have better broadband, better support for the private sector and public entities that are engaged in building infrastructure. And then we also cover and report on and include discussion about the controversies, the controversies around net neutrality, around privacy. Today's discussion is going to be maybe a little legal intensive, a little wonkily legal perhaps, but we're going to talk about the specifics of net neutrality in the courts. We're going to explore a now widely known, but originally not, doctrine called Chevron deference, which was overturned by the Supreme Court not 2 months ago, maybe just a month and a half. And that has already had real life consequences in terms of litigation surrounding net neutrality and the case and the court in which the FCC is litigating, the Sixth Circuit Court of Appeals. So we're going to talk a lot about that. We're going to dig deep into that. But before I turn to that, I want to just remind people about our upcoming events, remind people about our upcoming in-person event, Digital Infrastructure Investment, on September 19th. We'll have this for the 6th time, and in person. It'll also be virtual, but right now we're focused on the in-person component, and we're going all in on open access. That's the topic of Digital Infrastructure Investment this year. We are pleased to have sponsorship of Google Fiber, of the Fiber Broadband Association, and Utopia Fiber. If you're interested, please contact us. And we'd be happy to discuss how you can be part of a live event like the Digital Infrastructure Investment Summit. We also do this free weekly event, Broadband Breakfast Live Online. Next week, I'm going to be in Chicago at the Democratic National Convention. A month ago, we had reporters at Milwaukee for the Republican National Convention. We talked about crypto and the Republicans. Next week, we're going to talk about green energy and the Democrats. And then soon after that, we'll have events on kids and social media on September 4th, on data centers and the environment on September 11th, and a little bit later on cybersecurity, a broadband mandate. You can see all of these at broadbandbreakfast.com/BBLO for Broadband Breakfast Live Online. That'll take you to the page that shows you all of the upcoming events. And I also want to thank the sponsors of Broadband Breakfast. We would not be able to put these programs on every week for free to the audience of experts and people who want to be experts in broadband. And our sponsors include Utopia Fiber, Comcast, SmartWave Technologies, Ookla, Wesco, Coos Systems, the Institute for Local Self-Reliance Community Broadband Networks Initiative, the California Emerging Technology Fund, G-Fiber or Google Fiber, Broadband Now, Tirana Wireless, WISPA, Broadband Without Boundaries, and NCTA, the Internet and Television Association. And it's probably a best segue into our discussion, which will be about net neutrality, the past and future of net neutrality. I have open it up now to our view with our speakers and panelists. Feel free to turn your mics, your cameras on so that we can see all of you. I'm going to introduce our speakers, and I'll do it in the order in which they're going to give brief opening remarks. Again, we're talking about net neutrality, Chevron deference. That's the old doctrine now overturned by Loper-Bright, and the Sixth Circuit stay of the Federal Communications Commission's net neutrality order, or open internet order, as it seems to have now become. So our panel, we will hear first from Stephanie Joyce, Senior Vice President and Chief of Staff at CCIA, the Computer and Communications Industry Association. And Stephanie has been in this role after decades in private practice representing technology companies and competitive carriers before state, federal, and federal administrative agencies and the courts, and is an experienced advocate for pro-competitive policies, including advocacy for this open internet order that we are speaking about today. Thank you for being with us. I think the last time you were with us, Stephanie, as you said a moment ago, was when we talked about net neutrality before. So thanks for coming back in the repeat engagement. Let me just introduce our other guests, then we'll go back to Stephanie. Next up will be Daniel Lyons. Thank you for being with us, Daniel. He is a professor and the Associate Dean of Academic Affairs at Boston College Law School. And he's the Dean's Distinguished Scholar. I wonder if the Dean has more than one or just one Distinguished Scholar, but he is a Distinguished Scholar at Boston College Law School. He specialized in property, telecommunications, and internet law, as well as administrative law, and he's testified before Congress and state legislatures, including numerous proceedings before the FCC. He's also a non-resident senior fellow at the American Enterprise Institute. And Daniel, you've also been with us before. I think it was on TikTok, as you were saying. So thanks for coming back and speaking about a different topic than TikTok. We'll see. Maybe it's the same. We'll see. All right. And then next up after Daniel will be Blake Reed. Welcome, Blake. I think it's your first time with us, but we're super glad that someone has guitars in their studio because I don't have any guitars right now. But Blake researches, I guess his title first is the Associate Professor of Law at Colorado Law School. And there he writes on law, policy, technology, as well as internet copyright and disability law. As an associate professor of law at Colorado Law, he serves as the faculty director of the Telecom and Platforms Initiative at Silicon Flatiron Center, which of course has a great history, and probably many of our viewers know it's actually the place at which Michael Powell, then Federal Communications Commission chairman, declared the 4 freedoms of the internet that became, in a weird twist of fate, the net neutrality rules that now NCTA, for which Michael Powell is the CEO, opposed. And that led to NCTA versus Brand X, which of course we'll talk about in this episode. But anyway, back to the Flatirons Center, at which Blake is faculty director of the Telecom and Platforms Initiative. His work has been published in the Stanford Law Review, California Law Review, and Indiana Law Journal. And in 2023, he joined the author team for Communications Law and Policy, Cases and Materials, and Open Access Telecommunications Law Casebook. And open access, of course, refers to a different open access. We talk about open access networks. There's some commonality to open access scholarship, but super excited to have you with us, Blake, to talk about this topic. And then last up will be Seth Cooper. Thanks for joining us at the last minute to give us a balanced panel, perhaps. But Seth Cooper is Director of Policy Studies and a Senior Fellow at the Free State Foundation. He's the author of numerous articles and essays on all of these topics, as well as serving previously on the Telecommunications and Information Technology Task Force. He's the director of that, actually, at the American Legislative Exchange Council. And he's also been a state Supreme Court judicial clerk, as well as a state Senate caucus staff counsel. So thanks again for being with us. Seth, let's go ahead and turn it over to Stephanie to give us your thoughts on the changed landscape now that Loper-Bright has been decided.
Thank you so much, Drew, and it's always a pleasure to be with friends in broadband breakfast land. Time is a flat circle, and I'm back to talk about open internet. Almost 10 months after our last visit on this topic. Of course, I must begin by stating that these are my own views as Stephanie Joyce, a telecom lawyer, and are not necessarily the views of CCIA, though we did participate in this proceeding and its predecessors extensively. As an initial matter, won't belabor it, but of course, a stay is not a final ruling on the merits. It is preliminary, pending appeal. And the Sixth Circuit stated in a rather short opinion that open internet is likely a major question and that the Communications Act likely does not plainly authorize what the FCC adopted in that order. So TBD, and we look forward to merits briefing. I am an admitted telecom nerd. I think Drew called me a wonk. And I wrote a blog post on the topic we're discussing today in July in anticipation of the supplemental briefing that the Sixth Circuit required. And the title of this blog post was "The Open Internet Order Doesn't Need Chevron." And my point was that Loper-Bright left intact a very important tenet of administrative jurisprudence, and that is agencies are in fact experts, and courts certainly should listen closely to what agencies decide, especially on factual matters. In this open internet appeal, in this post-Loper-Bright era that we now live in, I think there's been some conflation of questions of law and questions of fact. And what Loper talks about is that agencies do not warrant judicial deference when deciding questions of law. But as we know, the open internet / net neutrality debate has always hinged on definitional issues, factual issues. What is broadband factually? That is the question that the FCC has answered several times and not consistently. Loper-Bright does not displace the Skidmore respect, we'll call it, to agency determinations of questions of fact. So I look forward to that discussion in the briefing. There's still much talk about that there's a question of authority before the Sixth Circuit. And again, the FCC has plenary authority to regulate telecommunications. That's not in question. What's in question is whether broadband internet access service is telecommunications. And so I want to draw a bright line between the question of law and the question of fact here. And it is that bright line that I think makes Loper-Bright not dispositive of the appeal. I will close by saying it's, quelle ironie that we again have a governmental body, here is the Sixth Circuit Court of Appeals, discussing how integral broadband is to American life, especially national security and public safety. And yet that governmental body has held preliminarily that some basic pro-consumer rules of the road still are not warranted. And I find that somewhat anomalous. What will happen to consumers during the appeal, those who subscribe at unregulated rates to broadband internet access? I think while the appeal remains pending, the status quo will prevail. And I see no change or any cause for alarm at this time. But I am hopeful that the FCC is able to demonstrate finally to the Sixth Circuit that its factual determination of what is broadband should not be thrown out. And if you don't want to use the word deference, at least use the word respect. And it should be listened to. I'm very pleased to be here, and I look forward to the remarks of my fellow panelists.
Awesome. Great introduction. Appreciate that fact versus law point and how that may allow defenders of open internet order to surpass Loper-Bright barrier. Let's turn to you, Daniel. Give us your thoughts on this topic.
Thanks. Yeah. So I teach both telecom law and admin law. So this short decision by the Sixth Circuit was like pure catnip to me, dropped in the middle of the summertime, right? I think something's exactly right that it's important. The important caveat here is that the court only found that the challengers were likely to succeed, but I think round one definitely went against the agency. So you had a three-judge panel, a Bush appointee, a Clinton appointee, a Biden appointee, who were anchoring their decision primarily in the major questions doctrine, like this idea that Congress generally makes the big picture policy decisions and agencies are only supposed to kind of fill in the details. The major questions doctrine recognizes that Congress could delegate big questions to the agencies, but if an agency is claiming authority over a question of vast economic and political significance, it has to show that Congress clearly intended it to do so. And I think as an application of the major questions doctrine, I think the court's probably correct. The question of net neutrality is a matter of economic significance. I think even the agency would agree with that. And I think its political significance can be attested to by the millions of comments that were filed in each subsequent net neutrality proceeding. And given that, I think that the court was probably right that there's no clear language in the 1996 Act that says broadband is unquestionably a Title II service. The 96 Act didn't really deal much with broadband, right? Back in that time, only about 50% of us had internet access. Most of us who did were accessing via dial-up, right? Which did that little like donkey static noise, like eeyock. And most of what the agency was focused on was, I'm sorry, what the Congress was focused on at the time was like manufacturing competition among local phone companies. There are a handful of references to the internet in the 96 Act, mostly in a provision that the Supreme Court struck down about regulating online pornography. So I think as far as the courts applied the major questions doctrine, I think it's right. The larger question is whether the major questions doctrine continues to be a thing, right? Because the doctrine was born as an exception to Chevron, this idea that normally courts should defer to agency views, but on the meaning of a statute. But for questions of vast economic and political significance, maybe we should think twice and check and make sure that Congress intended the agency to answer the question before providing that deference. And of course, Chevron deference no longer exists, right? Loper-Bright said that agencies are no longer owed deference on the meaning of their organic statutes by virtue of the fact that they are agencies. And so if that's right, and if major questions doctrine was just an exception to Chevron, then it's unclear after Loper-Bright kind of what role the major questions doctrine continues to play. If the major questions doctrine winds up being out of play, and I'm not sure which way the court's going to go on that, then it's going to be up to the agency to decide under Loper-Bright what the statute means. And Seffi noted that Loper-Bright makes room for courts to continue to recognize agency expertise. And this is the Skidmore doctrine, which is provides for deference to an agency, not because it's an agency, but because the agency's views are persuasive as sort of like an expert witness brief, right? This idea that agencies are experts on a topic and therefore their views, their opinions should carry more weight than the average person. But Skidmore is a fairly loose doctrine. And the Skidmore doctrine makes clear that the level of deference that courts should give depends on how persuasive the agency is, and in particular, how consistent the agency's explanation has been over time. And my sense is that Skidmore probably isn't going to do much for the agency in this case, because the FCC has gone back and forth several times about how broadband ought to be classified. And that suggests that its opinion wasn't driven so much by expertise as by sort of responding to the prevailing political winds. And so it's a situation where I don't think Skidmore deference is particularly strong. The challengers talked about this in the brief they filed on the merits yesterday. Their argument was that actually, to the extent that Skidmore applies, it should apply to the agency's original view, right, which is contemporaneous with the adoption of the original act's language. I'm not sure that's right either, but it is an interesting sort of inversion of that argument. Judge Sutton, in his concurrence, kind of addressed the question on the merits. Assuming this is de novo, I still think he says that broadband is not a Title II telecommunications service. I think he's right about that, but it's worth noting that there are several courts who which have disagreed in earlier rounds of net neutrality litigation. So I think my time's up. I'll leave it at that and kind of leave the rest for discussion.
All right, excellent. Thank you for those points about the major questions, doctrine, and other related topics, Daniel. Let's turn now to Blake Reed. The floor is yours.
Thanks, Drew, and nice to be with everyone this morning. So I'll try and not retread ground that Stephanie and Daniel have covered already. But just noting the Q&A here, I assume there are some folks here who are legal experts and some folks who are not. I think it's important to put this all in some political context because we're talking about this very formalistic legal question of administrative law and how the Supreme Court might or might not defer to the agency. I think it's important not to lose the sort of political forest for the legal trees here. I think it's pretty obvious where this is going to go. The Sixth Circuit has suggested that it's going to throw out the FCC's authority. I think it's pretty likely that that's where it goes on the merits. And if I'm counting votes on the Supreme Court, I count 5, probably 6 votes in favor of overturning this. And I think to a certain extent, all the legal doctrine we're going to talk about today is this sort of Potemkin version of administrative law that really is going to end up feeling like Calvin Ball by the end. I think the Supreme Court doesn't want the FCC to do this and is going to find a lot of different ways to get there. So I just wanted to preface that. One more thing I want to say about the politics is I think this is a really complicated position for the Supreme Court to take now that, or will be a complicated position for the Supreme Court to take now that at least several of the justices have thrown in for the idea that we ought to impose mechanics that look a lot like net neutrality. They're sort of, we might call them common carriage mechanics or non-discrimination mechanics, but that we ought to impose them on application layer platforms. So this is what happened in the net choice case. So I think the justices are going to be in an awkward position of trying to explain, just in terms of policy, why we ought to have sort of neutrality mandates for social media networks and search engines and that sort of thing, but not for the internet service providers that they ride on. I think any of the justifications that you might make for imposing those sort of interventions on application layer platforms make sense tenfold to apply to ISPs. All right. Enough about the politics. Let's like get into the formalism for a second here. I agree with Dan that the major questions doctrine seems more likely to lead the day. That's what the Sixth Circuit is relying on in the main in this stay order. The one place I might part company is I think that the major questions doctrine is actually going to be more important to the Supreme Court's and the lower courts review of agency decisions, at least in the near term, because it's a sort of fast answer. And if you want a deregulatory answer, it's kind of a thumb on the scale. It says, look, unless Congress has spoken to this rule that you want to make specifically, or this decision that you want to make specifically, then it doesn't fly. And it's a pretty quick shortcut over Loper Bright, which says we're going to de novo review the interpretation of the statute, which is quite complicated, right? For anybody that's taken a look at the FCC's many net neutrality orders over the years, they run into the hundreds of pages, and even the court's decisions reviewing them under Chevron are extremely long. And so this is a big task for the justices and the judges in the lower courts to do. And so I think the major questions doctrine is likely to carry the day for a while. But just to dive in real fast on Loper Bright and Chevron, I'll just say quickly, I think it's pretty obvious from Loper Bright that the court wants to throw out Brand X, the decision that sort of blessed the interpretation of the Communications Act application to broadband networks as ambiguous. The court all but throws out Brand X and dicta. There are call outs both in the majority opinion and in Justice Gorsuch's concurrence criticizing Brand X. Justice Thomas, who wrote the majority opinion Brand X, is with the majority on Loper Bright. If you listen to the oral arguments, Brand X gets thrown under the bus repeatedly. So I think Brand X is it's hard to argue that its days are not numbered. And I think it's an interesting, maybe kind of academic question to ask. Well, if the court reviews de novo and says, well, we're not going to just defer to the FCC's interpretation, well, what result do they reach? I think it's a little interesting to look back at the history and say, well, the last two interpretations of the statute by judges doing this sort of de novo were Justice Scalia in dissent in Brand X, concluding that ISPs or cable modem services were at least in part covered under Title II, and then the Ninth Circuit's decision in the Portland case that led up to Brand X, which likewise sort of concluded that there's a hybrid character to broadband internet services and that they ought to be covered. Theoretically, I think there are good arguments if the court is doing real coherent reasoning to take those seriously and maybe to follow those. I'm not sure that that's real likely, but I think there are arguments that are going to be had that are going to drag this out. And I'm about out of time here, so I'll just say one last thing, which is what is this all going to mean if this comes to pass? And I think it will take years for this to come to pass. I think we'll see states getting involved as they have been when the FCC has repealed net neutrality in the past or gone the other way in the classification question. But if this all really comes to pass, I think it's going to be very hard for Congress to legislate in this space, because I think the court has got a lot of tools to throw things out that are going to make it hard, even if Congress were inclined to act to make this stick. And I think the really scary thing about that is what we've seen for the entire first, call it, quarter century of the commercial internet is this, what I call like a Damoclean sword hanging over the ISPs, that even though we haven't had net neutrality as a really stable regime the whole time, the threat of it is right around the corner all the time. And it actually takes time. It takes talent and expertise and innovation to figure out how you might actually monetize the kind of discrimination schemes that net neutrality would prohibit. And we haven't actually seen ISPs go too far down that road, because there's always that threat looming that the FCC is just gonna sort of reverse things. And I think we might see, with that sword really removed, I think we might see some scarier and more aggressive behavior from ISPs. So that's kind of the thing I'm worried about, but I'll leave it there and look forward to the discussion.
That's the dystopian case there. So thanks for being with us. Let's go now to our final speaker before we open it to a fuller discussion. So Seth Cooper, the floor is yours.
Well, thank you, Drew. And I think a lot of the panelists sort of covered most of the topics, so maybe I can try and play in the joints and give a brief rundown of my view on it. Going into this, as someone who's filed comments and followed these proceedings for, I think, over a dozen years, including filing comments that led to this new Title II order, which unmercifully were around Christmas time and New Year's. These comment periods tend to be like in your summers, in your Christmases. This one was no exception. That got me mad. But each time you've gone through it, though, there's always new wrinkles. And of course, these were the major trends at the Supreme Court, sort of changed the whole situation. I mean, going into it with the new administration, it seemed pretty obvious, this being the Biden-Harris administration, that there was going to be a return to Title II. There had been a clear pathway using Brand X and Chevron deference simply to disagree with the Trump FCC's determinations about whether broadband internet access services were a Title I information service or a Title II telecommunications service. And, lo and behold, there's this silence at the court regarding Chevron for a long time. The major questions doctrine comes in. It had been there in the background in the past. The court really embraced it, starting with the West Virginia versus EPA decision, really clarified, we mean it. If there are matters of political and economic significance, Congress needs to provide a clear statement of authority. And that's there, and the FCC seemed to recognize this was a potential issue. It issued its notice. It relied nowhere on Chevron. I think it even disclaimed that it was relying on Chevron when it issued the final order. And paragraphs 252 and on of the FCC's new Title II order that came out this year, the Safeguarding and Securing the Internet order, tried to, I think, perhaps its most disingenuous claim is that this issue was not a politically or economically significant one. And whether or not you ultimately agree with the Supreme Court's doctrine or how you define politically economic significance, I think just by the FCC's own terms and the way they discussed this issue in the past of internet, and including the order, internet being vital to participation in society, vital to doing this and that, I think they were kind of boxed in, and they made their best lawyerly arguments that they could to try and get around that, saying, no, this isn't really that significant. And then by not relying on Chevron, which would have previously been their sure bet, they kind of had to come up with a novel theory. Right in September, when the notice of proposed rulemaking to change back to Title II came out, suddenly this issue about commercial, civilian, public internet networks became a national security, public safety issue, and common carriage type regulation suddenly became a national security device. I just didn't find it persuasive. And I don't think this will help. Ultimately, though, I think that the Sixth Circuit, and now this has been appealed, if I were circuit judge, and even with the Loper-Bright decision that just overturned Chevron, the major questions doctrine is what you have to deal with. And the Supreme Court hasn't dealt with the interplay very much or at all between the removal of Chevron and its overturning and the major questions doctrine. It kind of seemed to be kind of like a carve out or an exception to it previously. And so if I were the Sixth Circuit, I would probably have joined in that decision to stay the decision and hint strongly that this matter is a matter of political and economic significance, and Congress did not clearly authorize it. So, where the major questions doctrine will come down, or what it will serve in the meantime, I don't know. Certainly for lower courts, like I said, it's there. I think they will just simply use that. I think also, perhaps if there are questions that seem to kind of touch on the mixed questions of law and fact, not so much clear legal decisions, maybe the major questions doctrine comes in, the courts aren't going to defer, or that will serve there. I guess the other thing I could say is, I think going forward, just as an observer, it looks to me in reading the opinions like Brand X is just gone. It's just toast, because as was pointed out here previously, going back to the oral arguments in the Loper-Bright decision, Brand X came under fire. That wasn't the issue in the case, but it was an application of Chevron, an extension of Chevron, and you see it in the Loper-Bright decision. The Supreme Court kind of points to that. Chief Justice Roberts, Justice Neil Gorsuch. We'll talk about the flip-flopping and how the same provisions can mean opposite things over time, and that's a problem of the instability that came with Chevron, and Brand X was sort of exemplified that. So I think that one's kind of gone as a reliance. The future, I mean, there are weirdness of it as well. The major questions doctrine kind of postdates Brand X. It's hard to go back and try and picture how that means. All the justices in Brand X did seem to agree that cable broadband internet was an information service. It wasn't going from a Title II to a Title I scenario. It was not really. It was the FCC reviewing a decision where the FCC was simply trying to define something that didn't have a clear classification before. All of those things just add for weirdness, and I think it's just going to go away. I think it's just going to go away. So I think just going forward, as someone who didn't see, frankly, the problem that Title II was meant to address. Nobody was being censored on the internet. I sure hope that at least people are being censored on the internet, but they're not being censored by broadband internet service providers. And I would love to see a compromise. I would. I don't think anyone wants to see any blocking. I don't think anyone wants to see any throttling. It hasn't been there. How this plays out from the courts and where it goes from here, I don't know. But we're not going to see these rules go into effect anytime soon.
All right, let's dive in. Lots to deal with here. And I'm going to ask you both a question I've already previewed to each of you privately, but now I'm going to ask it two ways. So let's imagine there's no Chevron. Imagine there were no Chevron, right? And so instead we have the Loper-Bright world now. So I want you to answer this question for both 2005, when Brand X was decided, and for today. And they're obviously different situations, right? Because in 2005, it was a Bush administration FCC that was trying to, quote, take a deregulatory approach towards the internet. And now we have the Biden-Harris administration and their FCC taking a more regulatory approach. But how would each of those decisions, 2005 by the Powell FCC and 2024-23 by the Rosenworcel FCC, how would they have fared under the Loper-Bright world we're working with right now? So let's give each of you a chance. Stephanie, what do you say to that question?
Brand X is an anomaly and exists in a very strange place right now. In 2002, the FCC decided cable modems were Title I, even though 4 years prior it had said that DSL is Title II. Under Loper-Bright, as I said in my opening remarks, Skidmore respect, I'm going to use the term, still exists. It was not displaced. And Justice Roberts went in depth about the way that the court listened to agencies during the New Deal era, and nothing in his opinion disclaimed or rejected what the court had done. And so I do believe that the Title I decision would have been listened to, but certainly, as Justice Thomas stated in 2020 in his dissent in the Baldwin decision on cert, he said, I regret the decision and I'd like to reverse it. So I think Brand X very easily could have gone the other way under a Loper-Bright world. And today, with Loper-Bright being the law and the open internet having been painstakingly written to demonstrate as a factual matter that broadband is telecom, and because it's not in dispute that the FCC has plenary authority to regulate telecom, by listening to the FCC, I think it very well could be that the Sixth Circuit decides that even if this is a major question, and Drew knows my thoughts on the major questions doctrine, air quotes, even if it is, the FCC has been reasonable here. And it has very closely revealed the facts, looked at the facts, has an enormous record, and is the expert agency and has been since 1934. And so I think under Loper-Bright in this scenario, Title I could have been easily debunked, and the Title II definition certainly can be affirmed.
So just to be clear, you're saying that the Powell FCC would have lost. It would have been the held information service, and would have held to be a Title II regulatory world, and the Rosenworcel FCC would win. That's just what you just answered right now. Have I got that right?
I give the FCC in 2002 51-49 odds, and here's something that Chief Justice Sutton in the Sixth Circuit did not note in his very important concurrence. If you want to talk about the contemporaneous understanding that the courts now want to look for as to what an agency thought at a particular time when a statute was enacted, in 1998, the FCC had already held that DSL was telecom. And I think that would have easily weighed very heavily with the justices to say, why are you changing your mind? Why are you calling the same kind of connectivity Title I? So I think they easily could have lost on Brand X. And I truly hope and believe that they can win in the Ohio Telecom case at the Sixth Circuit.
Okay, great. Well, thanks for starting us off with a controversial note. Let's hear what Blake has to say. Daniel, what Daniel has to say about this.
Well, unsurprisingly, I think I'm going to take the opposite on both. And it's been a while since I've revisited this history, but I think the original DSL order was only referring to the transport element that was being unbundled for competitive carriers, which I think is a little bit different than the combined broadband offering that was at issue in Brand X. I may be wrong about that, but I think that's my interpretation, my recall. Brand X is interesting because it's asking a question that we've put in a different frame since then, right? I think the court, if you ask them separately, right, They were 9-0, I would suggest, on the question of whether the transport element of broadband is telecommunications. I think everybody agreed it was. And there were 9-0, I think, on the idea that internet access, right, using the broadband line to get to the internet and get services on the internet is a Title I service. The dispute between the majority and the dissent was, are these two separate offerings, or are they bundled as one offering? And it matters because bundling them meant you treat the whole thing as Title I. And that's where you get into the debate between Scalia and Thomas about, is the internet like pizza and pizza delivery, right? Or is it like a car dealership that also has an engine, right? You can take the engine out of a car and put a new engine in, but that doesn't, it still doesn't make any sense to say that a car dealership is in the business of selling engines, right? And so that dispute, I think, although Thomas relies on Chevron as a fallback, I think the beginning of Brand X, he sort of said, I think this is the better reading of the statute. And I think Brand X would have come out the same without Chevron.
Okay, and the Rosenworcel open internet order.
Yeah, and today I think we ask a different question, right? This whole like, is internet access a separate thing is not something that we talk much about at the agency level. It's one that Judge Sutton brought up a little bit, I think, and certainly plays heavily in the challenger's brief that was filed yesterday. I think that the key question that if the court ends up going on a statutory interpretation route, the key question that's going to come up is, what does it mean under the definition of information service to offer a capacity for acquiring, storing, manipulating information, right? If as broadband providers would say, when we're selling broadband access, we're providing the pipe and the ability to access stuff on the internet, maybe through third parties, but that doesn't matter. It's still a capacity to do this other stuff. Then I think the court comes out the same way, which means the current order gets struck down as a matter of de novo review. If they decline to consider that third party offering question, then I think there's a chance that the FCC gets upheld.
Okay, so the reverse. In your world, the Powell FCC would have won their attempt to make it an information service, and the Rosenworcel FCC would lose its effort to make it a Title II telecommunication service. Blake, how do you answer these two questions?
Okay, Brand X, I'm counting votes here. I think the Powell FCC loses this case. So I think you look at the Scalia dissent, which is joined by Justice Souter and Justice Ginsburg. I think you also have got Justice Breyer, who issues a concurrence sort of narrowly saying, I guess this is something that the agency could do going the other way under the Chevron framework. I think without Chevron, Breyer is in there. I think, you know, probably get Kennedy, probably get Stevens, who writes a separate concurrence. So I think this goes 6-3 in favor of the challengers to the agency action. I also just want to point out a weird part of Brand X, which is there's this part that overrules stare decisis in this case, because the Ninth Circuit has already reached a decision about this, and then the FCC comes along later with this sort of dog ate my homework declaratory ruling kind of thing, and the Ninth Circuit says, yeah, we already ruled on that. We don't defer to you when we've already resolved the question. And this is one of the most criticized parts of Brand X in Loper Bright. Justice Thomas says, oh, no, we throw out stare decisis when an agency has sort of gotten there first. So I think there's also going to be some consideration of the Ninth Circuit's opinion. And I guess the last thing I'll say is on the question of whether there's two separate things here, I guess that brings us to what we sort of understand now. I think that two separate components idea is something of the time of dial-up internet, when we all had a phone network and then we got our ISP service separately, and there was this idea about open access that we were really going to like conceptually divide the physical pipe and internet access. I think today these services are so integrated, and I think if we take Justice Scalia's logic from Brand X, that I think if we don't have Chevron and we're forgetting what I think are the kind of Calvin ball political dynamics happening at the Supreme Supreme Court and frankly at the Sixth Circuit in this, I think they look at it and say, look, everybody understands this is a transmission pipe. The internet is a thing that you pay for to go access applications like search and social media and video and so on and so forth. I think if we're doing an honest interpretation of what the Communications Act is driving at, and it's pretty obvious, the Communications Act is trying to be technologically neutral, right? The way the definition is written out, it's not written about the phone system. It's not written about the kinds of networks that were around in 1996 or in the previous iteration, the one that was around in 1934. It's written in these general terms about communications networks. So I think if we were being intellectually honest about it, I think the courts are going to uphold the FCC decision. I don't think the courts are going to be intellectually honest, and I don't rate the FCC's chances super highly.
So just to be clear, an excellent point, counting votes on Brand X, you're basically saying, it would come out the other side, the FCC would lose under the Loper-Bright standard. Well, what would happen today? Now here's weird because we have to kind of ask it, well, it's clearly changing what's already been changed. So would the FCC win on that?
The last half of my remarks were thinking about the FCC today. I think, again, if we do Loper-Bright faithfully, we apply Title II of the Communications Act in its technologically neutral sense, honestly, and we channel the insights of Brand X, I think the FCC today wins, the Rosenworcel administration wins, but I don't think that's what the courts are going to do.
I think it's a more purely political thing. And that's our next question up, but we're going to give Seth a chance to answer my two-parter at the start.
Well, this is a great exercise in working my mind into like a pretzel, trying to sort of retro and anachronistically figure this out. I do think I do think what would come into play would be also Section 230 definitions about interactive computer service that Judge Sutton raised in the Sixth Circuit stay. Which sort of excludes telecommunications, both 230 and 231, describes interactive service as an information service, provides access to the internet. These are all definitional terms that we've all batted around back and forth the last several iterations, from the PI FCC's order to what came before that. It was framed in a Chevron kind of situation, and again, just the framing is just weird because the posture that was going into whether it's at the time of Brand X, the two services versus one, you did have a lower court decision that interpreted things one way. The Supreme Court didn't quite so much tackle that head on. They brought in the deference and all of that thing. So it's a mess. That's why I say that decision. It's just no good to rely on going forward. For the courts. I just don't think so.
What if not what would have happened, what will happen now, right? Like what if there's no deference to the to the agency's rule on an ambiguous statute, as Chevron did in its Part 2 test, right? What will be the determination on this when it gets decided?
I just don't know.
Okay. All right. Well, we've got some great questions. I want to bring in politics, but I don't have a concrete way just yet to do that. So I'm going to start by asking questions we've got from the audience. Here's a great one from Michael Neely. If the courts reject the net neutrality order on the major questions doctrine, stating the FCC does not have plain language to regulate bias, broadband internet access service, do you believe the same logic would apply to interconnected VoIP, voice over internet protocol? I do not recall the net neutrality order ever addressing VoIP, specifically just bias. Any thoughts or comments on VoIP regulation? So again, let's give everyone a chance to tackle this one. How does VoIP regulation fare in the new Loper-Bright world? Stephanie.
Well, VoIP is telecom-y enough to have to pay in a universal service. We know that. IP is always going to be IP, but increasingly the FCC has taken a more functional approach to that dichotomy between analog voice and VoIP. If broadband internet access service is no longer Title II, either because the Sixth Circuit or the Supreme Court says so, I'm not sure that it would make VoIP any more regulable. I don't see the FCC getting more scope to reach into VoIP. That's a novel question. I'm glad someone raised it. It's forcing us to think a little bit. But look, if bias is not Title II, then VoIP isn't, other than for universal service purposes.
Daniel?
Yeah, I agree. I think my knowledge on the VoIP issue is a little bit dated, but I think most, if not all, of the FCC's action in the VoIP area has been in the exercise of its ancillary authority under Title I. So I don't think anything that happens with the Title II order is really going to change what the FCC is doing around VoIP. It has a limited amount of authority, but not the general regulatory power that a Title II classification would give it.
Quick thoughts, Blake and Seth?
Yeah, I'd just say this is if the VoIP companies decide to make a challenge to this, the sort of dog's going to catch the car, right? And the court's going to suddenly have to confront the unfun politics of deregulating what looks like the phone industry. And I think the way they might try and get at this is to say, well, actually, really what Title II has always been about is about the phone network. And this looks functionally enough like the phone network. Let's ignore all the careful analysis about what VoIP really is and that it rides over the internet and say, no, this is communications. I think they have to politically figure out a way to save that.
Jeff?
Yeah, I think that would probably be correct. They would at least from a critic standpoint, sandbag it and say this is at least functionally just like any other telephone service from an end user perspective, and they would probably just tie it up like that.
All right. We got to bring Scalia into this, right? And I'm going to use Scalia to be the political question here, because old enough to have actually heard Scalia speak specifically about Chevron and specifically defending Chevron. And the argument he used was that, look, it's either going to be the political power of courts or the political power of agencies. And he might have been saying this in a Republican administration. I don't remember, right? But the point I'm getting at is that, it's like Chevron is like dirt and everyone's, taking pot shots at it. But the way Chevron kind of came to be seen was as a very high burden that could be occasionally surpassed for that would curb agency power. But like, I want to just ask this question about Scalia's perspective, because as Blake, I think, pointed out, I mean, he was in the dissent on Brand X, and I just wonder if there is any sense in which when we have to sort of go from first principles, and we've heard both sides of this already from our panel here, on what way will internet be regulated, right? I mean, is this like the courts say, we just don't know, it has to go to Congress, or who gets the ultimate say? Because in our world of constitutional government, where we have an executive, a legislative, and a judicial, we also have independent agencies, and we have to figure out how those get treated. So I know this has probably been a little bit of a rambly question about politics and Scalia, but I do at least want to ask this, which is to say, where are we going to go without the standard that we had for so long, a guiding agency and administrative practice? Who wants to tackle that one? Go ahead, Stephanie.
I'll start us off, Drew, and thank you for that thoughtful question. I think that perception might be slightly overblown in terms of what Loper-Bright really did. Again, because it spoke very highly of the New Deal era in which agencies were making decisions and courts were listening to them, putting a thumb on the scale, because Skidmore still exists. And I think it's a question of degree and not an absolute rule. I can't live in a world where people truly believe that Congress are the world's experts on the utility network, the telecommunications network, EPA, pesticide standards, and that any statute would ever get passed if Congress were expected to become such experts. I think the reverence that Scalia showed for Chevron was sincere. And I think that the antipathy to Chevron in the last 10 years, let's call it, is born more of even Chevron was being stretched beyond what it was meant to do. And so I cannot surmise that agencies will truly be hamstrung in everything they're trying to do. I think the major questions doctrine proves too much. because everything these agencies decide has a major impact on interstate commerce and the nation's GDP. I think life is not as stark as we once thought. At first blush when Loper Bright came out, I think agencies will still be the experts. I think courts still want agencies to do good work. And I don't see Loper Bright as having entirely hamstrung every agency from acting. And I think there's a great deal of room left under Loper Bright for agencies to get the credence they deserve and to make certainly the factual determinations they need to make. And so long as they are reasonable, which has always been the APA standard, so long as it is a reasonable judgment on the record and sensible, I think the agencies will come out just fine.
I actually want to hear what Blake has to say about what Stephanie just said first.
Yeah, I mean, I just tack on and say, looking historically at Chevron, it's important to remember Chevron comes out of the Reagan years, right? And so I think the best way to understand where it comes from was invoking deference to agencies to protect what were then, Republican priorities. And I think as the politics shifted and the agencies became a more important home for Democrats to push liberal and progressive priorities, and deregulation kind of took hold as a keystone of the Republican program, I think that started to shift. So I think where this goes really depends on, are there institutionalists in the judiciary that sort of see, and I think you could see this tension in Project 2025, that see, actually, we need to have agencies to push forward Republican priorities as well? Or do the sort of deregulatory absolutists win the day and say, no, we want the courts to decide this decision every time, and we'll be damned if that, even if that means we have to throw out all the nuclear safety regulations and ask Congress to lay them out with specificity. I don't know where that's all gonna land over the next decade. And I also think the Democratic project of court reform starts to factor in as well, and how those two interrelate, we'll just have to wait and see.
Very interesting. All right, let's give the other side a chance. Daniel and Seth, what do you say to this?
Yeah, I agree with much of what Stephanie and Blake said. I'm not as legal realist, I think, as Blake is, but I think he's right that there's a strong political story behind Chevron. I would say Chevron becomes a darling of the right, in part as a response to war and court judicial activism. But judges like Scalia are super strong on Chevron, but also super strong on the court's role at Chevron step one, right? Working really hard to figure out the meaning of the statute before ultimately concluding, all right, it's ambiguous, go to the agency. And I think those work in tandem. Judges who do less work to interpret a statute are more skeptical of Chevron when it existed. But I think at the end of the day, right, I think you said it clearly, Drew, that is Chevron a good thing? Is Chevron a bad thing? Right? This is sort of a choice between two unelected organs of government, the judiciary or the agencies, as sort of which is the second best alternative to a functioning Congress. I think the message out of Loper Bright is the court really wants Congress to get its act together and start making the big decisions again. I think net neutrality is one of those decisions. I don't think Loper Bright is going to be the jolt that gets Congress going, because Congress's problems are much larger than that. But I think it's a step in the right direction.
Well, truly, our time has escaped me. I can't even believe it's already 1 o'clock here. So we're going to give everyone a chance to give a quick closing remark, starting with Stephanie, because I know you've got to go. So let's just go in the order we started. Final thoughts on where this issue goes.
Consumers' right to have unfettered internet access is never going to extinguish in my mind, and I don't think that those like me
is not going to extinguish. Is that what you said?
Is not. The telecom network is one of our nation's greatest assets, and telephone calls cannot be interrupted or futzed with. And I don't think broadband should be either. And so I don't think the open internet question is going away. I don't think that Loper Bright has killed any hope of ever having open internet rules. If it does, then the rest of the administrative state is in a great deal of peril as well. I think the fact that the nation keeps spending upward of $110 billion now on broadband just shows that we do take it seriously, that consumers rely upon it. It's integral to American life. And we're going to find a way to ensure that consumers are protected in their internet subscriptions. Thanks so much.
Thank you.
Thanks,
Steph.
everybody.
Okay, let's go quickly again to Daniel, Blake, and Seth. We'll give you an especially long last word there, but go ahead, Daniel, quickly.
Yeah, just really quickly. Net neutrality was Justice Gorsuch's sort of exhibit A of what was wrong with agency deference. I think the long-term answer to this problem has to lie in Congress. It can't lie in continuing to fight about what a Congress that was obsessed with local telephones said in passing about the rudimentary internet in 1996, right, when I was still in high school, tenure at a law school. I think that the ultimate solution is going to lie in Congress, and I actually think that's a good thing. I think when done well, the legislative process is better than the agency process at deciding these sort of big, highly politicized issues, because there's opportunities for log rolling, for swapping, for making sure that both sides of an issue have some input into the final solution. We almost got there in 2014. We didn't quite get across the finish line, but I think there's hope that it can get to a good place.
Another reference to log rolling as a good thing. Great to have you on, Daniel. Blake, your final thoughts before we go to Seth.
I'll just endorse all that Stephanie had to say and add. I think the good news is administrative law, even in this political era, moves slow, and I think there's still time for the judiciary and Congress to figure out how to back away from the ledge and protect the rights of consumers and analyze these kind of technocratic questions with the level of expertise that a specialized agency brings to the table. And I hope we figure out a way to get there.
Thank you. Seth, the final word.
Yes, it seems to be that going forward, given where this appeal has gone on the Safeguarding Security in the Internet Order Act from the Sixth Circuit and the composition of the Supreme Court and its jurisprudence on major questions, and now Loper-Bright, I don't think these rules are going to be enforced. And we will continue in this weird position, and hopefully it does get to Congress dealing with it. There are matters of ideology and financial self-interest that seem to be inhibiting any kind of brokered compromise in Congress over the years. The lawyers and the lobbyists always seem to make out the best, and regardless. But we can always keep trying. I think there is still enough uncertainty out there that coupled with the recognition that blocking access, throttling access of consumers would be a very bad thing. And that there could be forms of paid prioritization. That's another debate. Maybe it's good, maybe it's bad. Or there certainly could be bad forms. I'd love to see a compromise brokered. We will see. The only other thing I'd add is, Loper-Bright, it will, if there's a compromise, Congress doesn't have to decide every minute detail. But it does mean, though, that just pure interpretations of statute, it's not going to be the Scalia standard. It's going to be the John Marshall standard. Going of the judiciary's job is to say what the law is. And you're not going to be able to flip-flop their interpretations, and they're not going to be able to define agencies their own jurisdiction anymore. But there's still a way forward.
Great. Well, that is our last word. Thank you for being with us. To each of our panelists, Stephanie Joyce, Daniel Lyons, Blake Reed, Seth Cooper, and thank you to our audience for being here. I'm Drew Clark with Broadband Breakfast, and we'll see you next Wednesday at 12 noon Eastern Time to talk about green energy and the Democrats at the Democratic